All men are created equal. This phrase has been so often spoken and written, passed down from generation to generation, and wielded by so many people in so many causes at so many different times in American history, that it is almost impossible for us, nearly 250 years later, to experience its original force and meaning. It has become synonymous with a vague idealism, a hope that someday all people everywhere will live in a state of equality, and therefore also peace, harmony, freedom, and justice with one another, not unlike a wish for world peace. It has become the tool of the optimist and the target of the realist. What is often lost in this interpretation of the phrase is that all men are created equal was not originally stated as aspiration, but as fact. They didn't say, "We hope these dreams will come true." They said, "We hold these truths to be self-evident." The phrase is not in the subjunctive mood, but rather in the declarative. It was not meant to be idealistic. It was meant to be an affirmation of an actual reality. But how could it have been taken seriously as fact in colonial America in 1776? Perhaps many men were roughly equal in economic or political terms, but certainly not all. Perhaps women were more equal with men in colonial America than they were in Britain, but certainly not completely equal. And then, most obviously, there was the widespread practice of race-based enslavement, which established a more egregiously invidious hierarchy than any European aristocracy that had ever existed.
The truth of all men are created equal is something like the truth of all men are born naked. No matter what we're wearing, everyone is always naked underneath. Similarly, no matter how unequally we are treated in society, every single human being is always equal to every other human being. And why does this matter? Why is it more than just the tautology that people are equally people? Because of the words that immediately follow in the Declaration of Independence, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. Being human means more than merely being a member of a biological species. Being human automatically entails moral rights and responsibilities that follow as the logical result of our specific human capacities. In particular, our capacity for abstract thought and our self-awareness. John Locke had thought this through a century before the American Revolution. A contemporary of Isaac Newton, Locke accomplished something similar in the realm of politics. Just as Newton discovered the principle of gravity in its effects on the physical world, so Locke discovered the principle of natural human rights and its moral effects on the political world. In his second treatise of government, Locke argued that every human being, by their very nature, has an exclusive jurisdiction or authority over their own minds, bodies, and actions. No other human being has a right to invade this jurisdiction or to interrupt this authority. This is just the way humans are. It is the way they are created by what Locke called God's workmanship. It is this exclusive jurisdiction over one's own mind, body, and actions that Locke defined as human equality. He explicitly contrasted this definition of equality with other possible interpretations of equality, such as equality in age, experience, or virtue. Created equality can coexist with other kinds of inequality, just like born nakedness can coexist with clothing. The American authors of the Declaration of Independence saw equality in the way Locke described. The authors of the Declaration of Independence also shared with Locke an understanding of the relationship between equal human dignity and the broader moral framework within which this principle of equality exists. Along with natural scientists like Isaac Newton and other political philosophers like Hugo Grotius, Samuel von Pufendorf, and Richard Hooker, Locke held that the state of nature has a law of nature to govern it. In other words, all of nature is governed by rationally discernible laws, and human nature in particular includes within it a moral law that defines our obligations as human beings. This natural law underscored and supported human equality by imposing equal moral responsibilities on all human beings. The early Enlightenment view of the natural law was similar in important ways to the doctrine of natural law or natural justice espoused by ancient and medieval philosophers, such as Aristotle, Cicero, and St. Thomas Aquinas. Though these earlier versions of natural law thinking were often tied to certain conceptions of epistemology, ontology, and theology that the Enlightenment versions modified or rejected, in its basic idea of a given moral framework for all of humanity, the natural law doctrine remained constant. All of these thinkers, including John Locke, held that there is a fundamental order to the universe that we can know, and which, once we know it, obligates us to respect it and conform to it. One of the primary obligations the ordered universe imposes on us, which John Locke explored at length, and which the American authors of the Declaration took to heart, is the obligation to respect natural human rights and the equal dignity that flows from it. This is where the analogy between created equality and born nakedness breaks down. Being born naked doesn't impose a moral obligation on anyone to conform to this natural state in actual practice. Clothes are okay. Being created equal, on the other hand, does seem to impose a moral obligation on actual practice. Violating inalienable rights is not okay. And there may be other kinds of rights, civil rights, constitutional rights, or legal rights, that should be put in place in order to protect or ensure the exercise of natural human rights.
It is at this point that an immense distance, a tragic gap, an exceptional discrepancy opens in American history. The contradiction between the beautiful, self-evident principle of created human equality and the ugly, obviously wrong practice of the enslavement of African Americans is difficult for us to reconcile today. We are not alone, though, in wrestling with this contradiction. The idea that we in the 21st century possess a morally superior standpoint by which we are able to see clearly the wrong of racism and slavery for the first time is simply incorrect. The American founding generation possessed an understanding of this contradiction that was as clear, if not even clearer, than ours today. Thomas Jefferson, himself a notorious slaveholder, referred to slavery in his draft of the Declaration of Independence as a cruel war against human nature itself. John Jay, one of the authors of the Federalist Papers, said that to contend for our own liberty and to deny that blessing to others involves an inconsistency not to be excused. Patrick Henry wrote that the practice of enslavement was repugnant to humanity and inconsistent with the Bible. Benjamin Franklin called slavery an atrocious debasement of human nature. James Madison, in a speech at the Constitutional Convention, called slavery the most oppressive dominion ever exercised by man over man. People knew in 1776 and in 1787 that the practice of enslavement was egregiously incompatible with the self-evident truth of natural human equality and rights in the Declaration of Independence. But they allowed it to continue and even actively participated in it anyway. A number of reasons explain, without excusing, the actions of the American founding generation. First, they recognized the profound difficulty of managing the consequences of racism within conditions of equality. In other words, without the institution of slavery in place to reinforce racial hierarchy and keep the races separate from one another. The idea that there are distinct races of human beings, and in particular, the ideas of white and black races, was invented and normalized in order to justify the horrors of the transatlantic slave trade, in which the United States was an active participant. Racism was, therefore, responsible for the separation of humanity into different races. This separation was mentally necessary for modern Christian Europeans to rationalize enslaving their fellow human beings. Human beings like them had equal dignity, stemming in the belief of most Europeans from their equal creation in the image and likeness of God. Slavery could only be justified by artificially introducing a division in humanity significant enough to justify such a vast difference in morally acceptable treatment. Once slavery had given rise to racism, and racism to races, however, racism took on a life of its own, and races a reality of their own. Because races were tied to skin color, the most immediately obvious physical feature of a human being, which is, moreover, hereditary, the division between races and resulting racism was bound to outlive the legality of the institution that engendered them.
As Alexis de Tocqueville explained in Democracy in America, the institution of slavery actually functioned in some ways to forestall many of the social consequences of racism and discrimination, since it provided a clear, permanent, legal, and institutional embodiment of racial hierarchy. Without this legal and institutional pillar in place, the social consequences of racism could come crashing down throughout and across American society, reverberating in ways that might destroy American democracy altogether. Race-based slavery had been in place in the North American colonies for generations prior to 1776. Many leaders of the founding generation, including Madison and Jefferson, thought that white prejudice and black resentment would both prevent the forging of a harmonious interracial society after the abolition of slavery. For this reason, they advocated plans for gradual abolition alongside a process of colonization, which would send formerly enslaved people to West Africa. Prior to the Civil War, Abraham Lincoln also favored a version of this emancipation plan as the only one which would avoid destructive social conflict and upheaval following the abolition of slavery. Second, those whose livelihoods depended upon the value of enslaved people and their labor were reluctant to sacrifice their own financial well-being and that of their families to work for the abolition of the institution. Particularly for large slaveholders like Jefferson, Washington, and Madison, much of their family wealth was dependent upon the maintenance of slavery. The enslaved people themselves held enormous monetary value, and the value of the crops they cultivated and the land they occupied depended directly upon their labor. There were those, including fellow Virginian Edward Coles, who did in fact do just what Madison and Jefferson couldn't do by manumitting the enslaved people he inherited and publicly opposing slavery. But personal financial considerations were certainly prominent in the minds of many among the founding generation, who otherwise might have worked to end slavery in accordance with their moral and political convictions. Thirdly, there was the question of priority and sequence. It was unquestionably the case that the political unity of the American colonies during the Revolutionary War, and then of the American states afterward, would have been put to significant risk if leading advocates for national unity had made the abolition of slavery a political priority. Jefferson's paragraph about slavery was removed from the Declaration of Independence at the insistence of delegates from South Carolina and Georgia. The compromises over slavery in the Constitution were similarly put in place explicitly in order to placate delegates from southern states who may well have left the convention if such compromises were not made. Representatives of southern states knew how important enslaved labor was to the economic well-being of their constituents, even before the advent of the cotton gin. And these representatives would likely have prioritized the immediate preservation of their state economies over the longer-term benefits promised by a stronger national union. Those among the founding generation who valued both national unity and the abolition of slavery, then, basically had to choose between them. Both goals were extremely uncertain of success at the time. Among the two, there was a clearer path to national unity, and national unity could provide a platform for the abolition of slavery, whereas the abolition of slavery would not necessarily facilitate the goal of national unity. Faced with this choice, and also with the fact that national unity would benefit them personally and directly in ways that the abolition of slavery would not, the founding generation decided to prioritize national unity. Lastly, but not insignificantly, there was the fact that enslavement was something that was happening to other people. Moral opinion is cheap. Moral action is dear. Self-interest is often necessary to bring about the transition from the one to the other, and the self-interest of the white American founders was not sufficiently engaged in the abolition of slavery to influence their actions. This was the transition that happened to Abraham Lincoln in the mid-1850s, when the prospect of the nationalization of slavery through the Kansas-Nebraska Act and then the Dred Scott decision brought the issue finally to his own doorstep and led to Lincoln's transformation from anti-slavery sentimentalist to crusading abolitionist. It wasn't until slavery became an issue for him that Lincoln realized and felt the need to act.
When he did act, Lincoln did so in ways that attempted to make sense of the contradiction between the American Revolutionary and founding generations' political principles and their practice. On Abraham Lincoln's plausible but arguable interpretation, most of the leading advocates for national unity deliberately sought to place the institution of slavery on course of ultimate extinction by embedding the anti-slavery principles of the Revolution within the Constitution and early legislation such as the Northwest Ordinance. The Northwest Ordinance was a law made by the Confederation Congress in New York in 1787, while the Constitutional Convention was meeting in Philadelphia, and which provided, among many other things, that the U.S. owned land northwest of the Ohio River there would be neither slavery nor involuntary servitude. The language of the 13th Amendment, including the language about the exception in cases of a crime whereof the party shall have been duly convicted, was taken directly from the Northwest Ordinance. The U.S. Congress, in other words, passed the exact language of the 13th Amendment while the delegates to the Constitutional Convention were brokering compromises about slavery in the Constitution itself. In his Cooper Union speech in 1860, Lincoln used the coincidence of these events to argue mathematically that a majority of the people we call the American founders were in fact anti-slavery in their principles. The constitutional compromises themselves do not clearly fall on one side or the other of the slavery issue. What can be said of all of them is that they continued and supported the political status quo with respect to slavery, which was to say that it was a state-based institution regarding which the national government would be agnostic or neutral. The 3/5 clause duplicated a compromise made under the preceding Articles of Confederation and its essentially non-existent national government. The Slave Trade Clause prohibited the National Congress from changing anything about the practice as it then existed. And the Fugitive Slave Clause prohibited certain states, free states, from undermining the institutions of other states, slave states. In some ways, each of these clauses were valuable for the slaveholding interest. In other ways, each of them were harmful to slaveholding interests. The primary way in which each of these clauses and the Constitution as a whole were harmful to slaveholding interests was in referring to enslaved people throughout as persons rather than slaves. As Madison put it, the constitutional framers didn't want their work, the authoritative expression of the will of the people at the foundation of the new government, to reflect the mistaken opinion that there could be property in man. Apart from being mistaken, this opinion would run directly contrary to the self-evident principles of the American Revolution as expressed in the Declaration of Independence.
How then do we explain Madison's assertion in the Federalist Number 54 that, quote, "The federal Constitution, therefore, decides with great propriety on the case of our slaves, when it regards them in the mixed character of persons and of property. This is, in fact, their true character." If there can't be property in man, how can there be something with the mixed character of property and of human personhood? Wouldn't this be a walking contradiction, a simple impossibility? The unique context of Madison's statement here provides the key to interpreting his meaning. The statement is part of a very long quotation that Madison attributes to an unnamed Southerner. This Southerner subscribes to the view, a ridiculous one from the perspective of the Declaration's principles, and presumably from Madison's own perspective as well, that the 3/5 clause actually asserts that enslaved African Americans are equal to 3/5 of a human being. In order to really think this, the Southerner cannot agree with the Declaration's statement that all men are created equal. More than a decade had passed since the Declaration of Independence was written. Although the Declaration's philosophy, in some sense, represented the American mind of the time, there were dissenting opinions, as well as alternative philosophies on offer. These dissenting opinions and alternative philosophies had their adherents among the founding generation, particularly in the slaveholding South, and subsequent generations of Southerners would adopt these alternatives with increasing attachment and vehemence in the time leading up to the Civil War. Democratic Senator John Pettit went so far as to publicly state in 1854 that the Declaration's principles were self-evident lies. Lincoln was one of the most influential American leaders who affirmed the continuing truth and relevance of the Declaration's statements of created equality and inalienable rights into the middle of the 19th century, harking back directly to the Declaration of Independence in the opening line of the Gettysburg Address. Although he was a dedicated constitutionalist, Lincoln notably skipped right over the Constitution in identifying the date on which the United States was conceived in the womb of liberty, and with DNA that clearly read, "All men are created equal." In Lincoln's view, what the Civil War would accomplish would not be a surgical repair of the nation's flaws, nor a cosmetic enhancement of the nation's image, but a kind of cloning of the embryo of 1776, a new birth of freedom that would allow the United States to avoid perishing from the earth. This recapitulation of the American founding would allow the American experiment in self-government to proceed as it should have from the beginning, without the circumstances of enslavement and unjust discrimination that had stifled the development of American constitutional democracy like a toxic gas in a nursery. Lincoln devoted the final months, weeks, and days of his life to disentangling the threads of constitutional compromises that had allowed the Union to be formed at the price of allowing the Southern states to retain the right to enforce legal slavery on African Americans. The new birth of the United States under Lincoln's leadership would discard the old contradictory thread of enslavement and legalized racism, and retain and extend the threads of freedom and equality.
Arguments that the Civil War was about states' rights rather than slavery are quite simply wrong. Not because the Civil War wasn't about states' rights, but because the issue of states' rights from the beginning, especially by 1860, was inextricably tied to the issue of slavery. In July of 1787, in the middle of the Constitutional Convention, the discussions of the delegates, as recounted by James Madison, shifted from debates between the small and the large states to controversies between the northern and southern states, that is, between the free and slave states. States' rights were a legitimate issue throughout the Constitutional Convention, as they had been throughout the Revolutionary War and under the Articles of Confederation. But beginning in the Constitutional Convention, if not before, states' rights became intertwined with the slaveholding interest. And as the 19th century wore on, this connection grew tighter and tighter. John C. Calhoun, the most influential Southern politician in the first half of the 19th century, simultaneously argued that the enslavement of African Americans was a positive good, and that the states were sovereign entities which should not be obligated to follow the majority rule of the people of the United States. The two issues went hand in hand, with states' rights increasingly taking a subordinate position to the argument over slavery. In his final debate with Stephen Douglas in 1858, Abraham Lincoln highlighted this point by stating that the real controversy was between those who viewed slavery as a wrong and those who did not. Lincoln's debates with Stephen Douglas provide vivid evidence for the way in which the continuing distance between American principles and American practices drove the conflict that became the Civil War. And Lincoln's friendship with Frederick Douglass, that is Douglas with the extra S, that makes all the difference, provides further evidence for this fact. Frederick Douglass shared Lincoln's devotion to the principles of the Declaration, as well as his hope that the constitutional union could be made to affirm the application of those principles to the situation of African American enslavement. In addition to this agreement on theoretical principles, Douglass possessed a clarity of understanding derived from direct experience of the tragic gap between these self-evident principles and the horrors of enslavement. In a famous speech he gave to the Ladies' Anti-Slavery Society of Rochester, New York, on July 5th of 1852, Douglass began by pointing out that the distance between this platform and the slave plantation from which I escaped is considerable. Douglass continued to stretch at both ends of this metaphorical expanse for the remainder of the speech, speaking with equal earnestness and vehemence of the injustice of enslavement on the one hand, and the importance of American moral and political principles on the other. On enslavement, Douglass spoke directly from the heart, from his own experience, and from self-evident common sense, at one point imploring his audience to consider the poignant rhetorical question, "Would you have me argue that man is entitled to liberty?" On the issue of the humanity of enslaved African Americans and the nature of the injustice to which they had been subjected, Douglass followed the Declaration of Independence in asserting the self-evidence of his natural human rights. On this point, no argument was possible, and none was necessary. As he put it, light was not needed, but fire. To argue for natural human rights for Douglass, as for the Declaration, would be like using a lantern in broad daylight. The issue was one of willful ignorance or denial. The light of understanding was present, but the fire of courage and of love was woefully absent.
On American principles, particularly those contained in the Constitution, Douglass, like Lincoln, spoke like a lawyer. Douglass argued that the Constitution should be taken according to its plain meaning, according to the words in the text, rather than assumptions about intention derived from the circumstances of the time or the behavior of the authors. Interpreted in this way, Douglass challenged his audience to find one pro-slavery clause in it. Douglass argued rather that the Constitution contained principles and purposes that were clearly opposed to slavery, rendering it, as he said, a glorious liberty document. Douglass ascribed the diseases of slavery and racism to the moral blindness of the American people and exhorted them to live up to the commitments expressed in the founding documents. Douglass agreed with Lincoln's diagnosis of the relationship between racist slavery and American founding principles. They were diametrically opposed to one another, separated by an enormous and tragic distance. American principles could and should be used as foundations, supports, and allies in combating racist slavery, pointing the way past racism and toward a future built on equal human dignity. The 13th Amendment fulfilled the wish of many of the constitutional framers by mentioning slavery only to condemn it. The 14th Amendment finally carried the Due Process Clause of the 5th Amendment, the equal protection implications of the preamble, and the nationalized citizenship prefigured in the Privileges and Immunities Clause into the slave states in an attempt to destroy racist violations of these principles within those states. And the 15th Amendment attempted to ensure that political rights would flow from the civil rights for formerly enslaved African Americans as they had for white Americans. Tragically, after a brief period of initial success, none of these goals would be realized in practice for another 100 years. After the withdrawal of federal enforcement in the southern states, those states worked to reestablish the political, legal, economic, and social hierarchy that had been dismantled by the Civil War amendments, rendering these amendments all but a dead letter for generations to come. The Supreme Court provided cover for the former slave states through decisions like the Slaughterhouse cases and Plessy v. Ferguson, which removed the intended effects of the Civil War amendments and exposed African Americans to violations of due process and equal protection without any legal recourse. These violations often took the brutal form of lynching, which was widely used throughout this time as a deliberate and systematic way of enforcing racial hierarchy throughout the South.
Frederick Douglass lived long enough to witness this depressing development. In 1895, shortly before his death, Douglass wrote a preface to Ida B. Wells' book, exposing the practice of lynching, in which he praised her work as a service which can neither be weighed nor measured. And he extolled Wells herself as a brave woman. Ida Wells' publication of the book was indeed a tremendous act of bravery. As she no doubt anticipated, she suffered significant personal and professional injury as a result of its publication. She covered the brutal murders of innocent men and women, exposing the ugly underbelly of the mainstream society, groups like the Ku Klux Klan, and the law enforcement that turned a blind eye to the brutality and sometimes participated in it. Her newspaper, the Memphis Free Speech, was burned to the ground, and Wells was forced to move away from Memphis to Chicago to escape the imminent threat of violent death. Surrounding the violence of racist terrorism, like poison gas hovering over a battlefield, was the legal regime known as Jim Crow, which excluded African Americans from the civil and political rights that Americans had always held dear, the rights listed in the Bill of Rights, as well as freedom of movement, the right to participate in the free market, and the right to vote. Booker T. Washington epitomized the heroic resiliency of many African Americans throughout this time, persisting through the legalized racial hierarchy of segregation to build successful educational and economic institutions. His approach of gradual progress and of earning civil and political rights with the consent of Southern white people rather than by immediately demanding them drew criticism from many at the time. The most prominent of these critics was W.E.B. Du Bois, who thought that civil and political rights were immediately owed to African Americans, and that they should therefore demand these rights instead of accommodating the preferred timeline of white Americans. In his Niagara Movement speech, Du Bois connected this cause to American identity by saying that it was a fight for ideals, lest this, our common fatherland, false to its founding, become in truth the land of the thief and the home of the slave. Neither Washington nor Du Bois would live to see the next stage of legal progress in achieving freedom and equality for African Americans that was brought about by the Civil Rights Act of 1964. In fact, Du Bois died the very day before Martin Luther King Jr.'s iconic I Have a Dream speech during the March on Washington in August of 1963. Martin Luther King Jr.'s philosophy of humanity, society, and politics was extraordinarily complex and changed over the course of his too short lifetime. The I Have a Dream speech expresses one crucial component of this philosophy: its connection to the principles of the American founding. In this speech, King introduces the now famous check cashing metaphor to describe the relationship between American founding ideals and their application in American political practice over time. We've come to our nation's capital, King said, to cash a check. When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every American was to fall heir. This note was a promise that all men, yes, black men as well as white men, would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness.
King's successes in leading the civil rights movement stemmed from the intellectual brilliance and rhetorical skill with which he weaved together fundamental principles of American identity with Christian theological doctrines and natural law philosophy. This potent concoction hadn't been employed since Frederick Douglass did so in the previous century, and hasn't been used by any American civic leader with anything approaching King's influence in the time since. Even in the heyday of his cross-racial popularity and his public endorsement of the importance and truth of American founding principles, King, like Frederick Douglass, wasn't afraid to highlight the injustice of the segregation and discrimination that had succeeded legal slavery in the U.S. In one of the most poignant moments of his letter from a Birmingham jail, and just before his more famous statement of natural law philosophy, King relates his experience of breaking the news to his 6-year-old daughter that Funtown is closed to colored children, and of seeing the ominous clouds of inferiority beginning to form in her little mental sky. In his reflections upon this experience, as in his expounding of American ideals, King delved deeply and precisely into the core of their significance. The principles of the Declaration of Independence, and to some extent at least of the Constitution as well, are about fundamental and equal human dignity. They are about the equal, because unquantifiable and immeasurable, value of each and every human being. Whether this is expressed in terms of equal freedom, equal endowment with natural human rights, or equal creation in the image and likeness of God. Despite the immensity of the distance in time and circumstances separating King from Frederick Douglass, Abraham Lincoln, and Thomas Jefferson, they each shared this identical insight, and they each used it as the touchstone and pole star of their civic leadership. The successes of the civil rights movement, like those of the Civil War era, the abolitionist movement, the founding, and the Revolution, all followed in some way from this singular source.
If only this were the end of the story, we would all love to be able to close at this point with the pronouncement that they all lived happily ever after. As we all know and have been made to see clearly in the past few years, if we didn't before, this is far from the case. Tensions and injustices stemming from the history of racist enslavement and racist segregation continue to persist in American society, and the all too human failings that gave rise to overt racism in the past continue to affect human beings in a myriad of ways in the present, in public tragic events, and in less overt but no less real and significant ways. The American ideals that represented the best of our founding and early history are little understood and only seldom taken to heart by most American citizens. Empty sentimentalism abounds, while the kind of real conviction that animated the Kings and Du Boises and Welleses and Douglasses, still present in a new generation of Americans, is often ignored or vilified.
Spreading knowledge of racism, both its proponents and its counteragents, in American history is one crucial step. Inspiring the courage to care not only about justice in the abstract, but about other people and other Americans, including those who look different from us, is another. We can do this in our schools, in our classrooms, and in our communities. By living in truth and acting in goodness, we will ultimately realize the potential beauty of our diverse American society.